Good evening, everyone, at least the wonderful city of Wilmington. I am Leroy Tice. You are welcomed to the initial installment of The Bar. On The Bar, we are going to discuss legal subjects, both locally and nationally. Brief introduction of myself. Again, I am attorney Leroy Tice. I'm a practicing lawyer here in the city of Wilmington and throughout the state for that matter. I'm a proud Delaware State grad, a Seton Hall law grad. And after law school, I clerked for one of the esteemed gentlemen who is here at the desk with me tonight. So I want to have these gentlemen introduce themselves. Former Judge Charles H. Toliver IV and former Chief Judge Alex J. Smalls. Judge Toliver?
Good evening, Mr. Tice. Good evening, Judge Smalls. My name is Charles Toliver. I am a native Delawarean, a proud graduate of Hampton Institute and now Hampton University, and the University of Virginia School of Law. I worked for the city of Wilmington for 3 to 4 years, then went into private practice and was appointed to the bench in 1990, and I retired in 2014. Worked for a law firm before retiring again and coming to work for Mr. Tice.
By the way, you don't work for me, you work with me, and I'm sure I was your best law clerk, and that doesn't say anything about anybody else to clerk for you. Judge Smalls.
Good afternoon,
former Judge Smalls.
Mr. Tice. I appreciate the opportunity to appear with you. Good afternoon, my colleague Judge Toliver, which I've known all of my legal career. My former career was I started with the City Solicitor's Office as a prosecutor in the municipal court, and then I was a Deputy Attorney General in the Department of Justice, went to work for the City of Wilmington, where I was a Director of Public Safety, and then I was appointed to the bench at municipal court, and then elevated to Court of Common Pleas and the Chief Judge. On that court, I served on total judiciary of 29 years and retired in this past May 1st. And I've been pleased to join the firm with Mr. Tice and Mr. Toliver.
Very good. And I think from the outset, I must state on behalf of myself and for the gentleman on the panel, kind of a disclosure of sorts, that this is merely editorializing that we are doing here tonight. This is, the discussion is not intended to constitute a legal opinion or any legal advice. And if this particular installment were to be given a title, it would be Kyle Rittenhouse and Ahmaud Arbery, was justice served? And Ivan Thomas of DETV wanted us to come on and talk about those two verdicts, decisions. Obviously, given the nature of the times we are in and the implications of both of those decisions. So as we get started, I just wanted to kind of frame a part of the discussions that certainly forms the foundation of our systems of justice, our rule of law in this country, and that is notions of justice and fairness. You know, these notions are the aims of an ordered society generally, and again, our system of criminal justice more specifically. I have extracted definitions of these two words from some of my readings. Justice, I have personally come to conclude, means that the decisions that come from court hearings or other decisions made by decision makers, ones that are just are decisions that unify the community rather than divide it. Fairness, on the other hand, relates to the equality of process. Everyone gets a certain process that is due all. Any reflections, gentlemen, with respect to you know, how you define justice and/or fairness?
I think justice encompasses fundamental fairness in terms of being able to put your case before the trier of fact. And the system should facilitate both the defense and the prosecution an opportunity to have fundamental fairness, which the equal access to justice with a fair and impartial hearing. I think once you have that, I think you have the foundation for the good system.
I view it maybe a little differently, but not much. I believe justice requires, in the first instance, fundamental fairness, a fair process, and the process is both procedural and substantive. One must be afforded a certain mechanism to present their claim or defend it, and one must also be able to present a case that is societally, I guess in terms of the community, fair and appropriate based upon community and societal norms.
As we go into the discussion of the Rittenhouse and Arbery cases more specifically, I want to talk about the times in which these cases came to a verdict. And obviously, without being political, because obviously the law should not be political, though there may be some undertones. I don't know that I've experienced times like these post George Floyd, post our 44th president, where there were kind of racial grievances on both sides, and these cases come as the country is going through somewhat of a reckoning, and there are protests. You can characterize the protest however you wish. And I've asked you gentlemen, you're slightly older than me, not much, just about, in terms of, I'll call it a racial divide, for the lack of a better descriptor. Have there been times in your lives when you have felt like there were these types of racial grievances on both sides or tensions? Do you feel it now, and have you felt it before?
I think that there has always been a racial divide in America since the first slaves were brought here. And I think in the 50s and 60s and even the 40s and the start of the Civil Rights Revolution, the focus was on a form of equality. I think recent years there has been a greater awareness of what has happened and what people feel entitled to protest. So I think it's more open now. Before, I think it was under the surface more than it was out in the open as there is now.
Your response?
I think to follow up on what Judge Toliver said, I think there is a greater stress on the system in terms of the competing positions. I think people who are coming to the courts today see maybe an imbalance in terms of the number of people there and the type of people there. And that is a little bit troubling. But I think the system itself is being tested, and I think the lawyers has an obligation to at least bring forth those issues so that the courts will have an opportunity to really confront them and attempt to resolve them, because these issues will not go away.
Yeah, well, and that's well put. Obviously, the issue of race does not go away. The issue of, I guess, differences in whatever regard, socioeconomic or status, the differences don't go away in this country. And I don't know necessarily how we will resolve those differences, but I think we'll come back to that point later on in the discussion. But I want to go right into Rittenhouse, and any discussion about a verdict, a legal matter, needs to start with fundamentally kind of what the facts were. I find when people discuss these things, oftentimes the facts are not agreed upon or are altogether ignored. So I just, we kind of set the tone with respect to kind of the racial grievances on both sides, and it's kind of a time of protest. And dealing with the Kyle Rittenhouse case, criminal complaint coming out of Wisconsin, and it's titled Wisconsin versus Kyle Rittenhouse. You might recall the facts occurred, or the incident occurred in Kenosha, Wisconsin, in the midst of a protest concerning Jacob Black, a young African-American, Jacob Blake, excuse me, a young African-American male who was shot 7 times in the back on August 23rd of 2020. So I think our understanding is that Kyle Rittenhouse came to Kenosha. He's a 17-year-old young man at the time. He came to Kenosha with I believe it was an AR-15 type rifle, and unfortunately these days pretty much everybody has some experience with these things or has some awareness of these types of weapons. And he came into Wisconsin, downtown Kenosha, and there's where, in the middle of this protest we're talking about concerning Jacob Blake, and that is where the events occurred that ultimately concluded in his being charged with several crimes. Really quick, reading from the criminal complaint, count 1, first-degree reckless homicide. That was with respect to a Joseph Rosenbaum, and it was alleged that Rosenbaum threw an object at Rittenhouse. Rosenbaum advanced and moved toward Rittenhouse. Rosenbaum made a reaching motion for the weapon, and Rosenbaum was shot 4 times at close range. Count 2, first-degree reckless endangering the safety. That regarded a Richard McGinnis, who was actually a reporter, who was on the scene, and I believe that the brief facts around that: a firearm was discharged in Mr. McGinnis's general vicinity. Count 3, first-degree intentional homicide, use of a dangerous weapon. That charge regarded a Anthony Huber. Brief facts about Mr. Huber. Rittenhouse was on his back at that time, and when he was approached by Mr. Huber was alleged to have reached for Rittenhouse's gun with his left hand and threw a skateboard with the other. When Huber tried to pull the gun away, he was fired and struck once. He was fired at and struck once in the body. Count 4, and I'll do this as quickly as possible. Attempted first-degree intentional homicide, and that related to a Gage Grosskreutz. Mr. Grosskreutz had a firearm in one hand, had his hands raised, and Mr. Rittenhouse fired one, striking him in the arm. There was also a 5th count of an unknown individual where Mr. Rittenhouse was laying on the ground on his stomach, on his back, and was alleged to have shot at an unidentified person. And the last count, count 6, was possession of a dangerous weapon by a person under the age of 18. And in Wisconsin, there was a law on the books as it related to young people under 18, not permitted to have short-barreled firearms. But in this particular instance, the judge dropped that particular charge against Mr. Rittenhouse because he had an AR-type weapon with a barrel that was at least 12 inches long. And his defense was that there was a carve-out for the 12-inch long barrel. Do either of you gentlemen, as former judges, have any reflection on the judges dismissing that initial gun possession charge?
The Rittenhouse case in and of itself is troublesome because of its factual contact, but if you take away some of that and you look at what the judge did, he concluded that even though Rittenhouse couldn't own a handgun, he could own a AK-47 because of the way he construed the statute in terms of the barrel length. And in the arguments they made, the defense says, let's look at the arguments or the record when they created this law. And they argued that if you have this weapon with this length, then you are permitted, not focusing on AK-47. And I think what
AR-15.
AR-15, but the judge, I don't think, looked at the context of the law. I think what the context of the law was is that we permit young people to have hunting weapons, but not weapons of mass destruction. And I think that's where the argument is, and I think that's where the prosecution and the defense differs on the issue, and the judge came down on the side of the defense on how he construed the statute.
Sir?
I look at it a little differently in the sense that if the statute was clear, and it was, that there was an exception for rifles of a barrel with a certain length, then it was fairly straightforward. Now, Judge Smalls is probably right in terms of the legislative history, but you never reach that if the language is clear, at least in my view of it. And so I don't think it was legally incorrect based upon the wording of the statute, and if the General Assembly or whatever the legislative body was wanted to specifically say guns used for hunting, then they should have said it, and there's no indication that you can't use an AR-15 style rifle for hunting, and indeed some people do. Why, I'm not sure, but some people do.
So, I mean, ultimately, I think we arrive at the conclusion that, I mean, in this case, the judge decided pretty much along the lines of, I guess, just a straightforward reading of the statute without reading anything at all into it. But as most issues in the law are, I mean, you can always kind of get to maybe. So the gun ultimately, the gun charge was ultimately dismissed. We've talked briefly about kind of the facts of the case, very brief. But I want to go into the kind of the general principles of self-defense, because that's what was at play in this case. And in the jury instruction, it was laid out very clearly by the trial judge as to the general principles and kind of what the jury was to consider with respect to self-defense. I'm just going to briefly go through what the jury was told. They were told that the law of self-defense allows a defendant to threaten or intentionally use force against another only if the defendant believed that there was an actual or imminent unlawful interference with the defendant's person. The defendant believed that the amount of force he was to use or threaten was necessary to prevent or terminate the interference, and the defendant's beliefs were reasonable. And the jury was instructed on what is reasonableness, what reasonableness is in this regard. In Wisconsin also, there's no duty to retreat, and that's what the jury was told. Also, the jury was told that that Mr. Rittenhouse could not provoke the things that transpired, that rely on self-defense. So as we look at the verdict that came down as to all the counts against Mr. Rittenhouse, he was deemed by this jury to be not guilty of all 5 counts that remained against him. Did this jury get it right? Judge Smalls?
You know, questioning what the jury's thought is always difficult, because the 12 people or the 6 people that was handling this case, they came with the idea, I have a duty to discharge as a citizen in a system where parties are to present their cases. But in this case, Rittenhouse brings an AK high-powered rifle to a disturbance. That's like bringing gasoline to the fire. He's there after curfew. There's a question about whether he can own the gun. So all those issues puts this case in this unique context. And I think when you look at a lot of the transcript, the question is whether the prosecution was given a fair opportunity to present its case. And that's the question, because the jury only got what is before it. So I think the jury did a good job in terms of what it had, but the question is what it got.
So, Judge Toliver, before you answer the question, I just want to go through, because Judge Smalls pointed out kind of some of the arguments that were made by the prosecution and the defense. So I want to just kind of highlight some of those arguments. So the prosecution, first off, who has the burden, obviously, claimed that they had drone video showing Rittenhouse provoked the confrontation. And I believe that provocation was pointing a gun at a bystander, they claim. So I believe that's in part what the jury heard. And the defense, conversely, described the events of August 25th, 2020 a little differently, explaining that Rittenhouse fired his rifle only because he was threatened by people in the crowd, beginning with Mr. Rosenbaum, who chased him, and then we saw what ensued going forward. Again, same question directed to you, sir. Did the jury get it right, given what we know, and again, the disclaimer being that we haven't seen all the evidence?
Based on what was there, and it all turns on what was presented to the jury. And I think that the biggest thing is, and it's a complicated area. So you go to a protest to protect property of a place you don't live, and to assist those who are being demonstrated against or have a threat against their property. Not illegal, not wrong. Might be certainly extremely ill-advised, but not illegal. And assuming for the point of argument that he could have that gun, he has a constitutional right to have a gun. I mean, it's hard to get around that. Now, the question is, what was the provocation? The provocation, or whether the provocation was him going there, him standing on the outskirts of a demonstration, him showing that he favored, which I guess he did, the counter demonstration. But the most difficult part is, and I saw it in one of the pieces that you gave us, first of all, as a matter of common sense, don't chase somebody with a weapon because you might catch them. And it's like the dog chasing a car. You get the bumper, what are you going to do? Now, that's common sense. That's not necessarily the law. And what I say to that is, even if your presence provoked a response, when someone charges you, as the first victim did, and he threw an object at Rittenhouse, advanced and moved towards Rittenhouse, made a reaching motion for the weapon, and appears to touch the weapon. What are you supposed to do? Do you, at that point, because you came to the demonstration, because you had a firearm, do you not defend yourself? And that's the difficult part about self-defense. Now, if the provocation was being there and he didn't do something to Mr. Rosenbaum, and then how far do you waive self-defense if I swing at you, being 20-some years your senior, and let's say my physical conditioning is not great, I start the confrontation, and then you decide to do something untoward, should I just, the law requires me to stand there and take it even though I started it? I don't know where it starts and begins, but I do believe you have to look at the facts, and I don't believe that you surrender your right to self-defense, particularly when the facts in this case show he tried to run away and fell and was hit. At that point, I don't know what you can do. It's an unfortunate situation, and maybe the police should have done a better job of keeping the protesters from those who were contrary to the protesters. But I don't disagree necessarily with it, because when you put the two groups together, something bad is likely to happen. I don't know why they let this guy with this AR-15 in close proximity. That's the part I don't understand, because in the best of all possible worlds, I think that it's like putting a can of gasoline, to use Judge Small's analogy, next to an open fire.
And I think at one point he told someone that he was either an emergency responder or was there for medical treatment purposes, and I think whoever he told bought that piece of misinformation. But
Well, I mean, I don't know, but I don't think you need an AR-15 to administer emergency medical treatment unless it's terminal care. And he wasn't a hospice worker, so I think that.
I think we can agree upon that.
I think, though, is that when you look at Rittenhouse testimony, his attorneys did an extremely good job in terms of preparing him for trial, because his entire testimony was that I was not protecting property. I was defending myself against the attackers, and that you can do. And once you can get the jury to believe that, then I think you get a not guilty verdict.
But don't, I
And
mean,
no duty to retreat.
and he was protecting himself. Now, whether he started it or not, or should have been there or not, clearly 2 people attacked him. Now, did they have a right to attack him because he was there? And those are larger questions in my mind, and I don't know. But once he was on the ground and the guy hit him with a skateboard, I'm not sure what you're supposed to do. Lay there and take it?
I think, however, is that you have to start with the basic premise, is that you cannot bring this type of weapon to a protest. You cannot be at the area when the curfew says you need to be somewhere else.
But nobody should have been there then.
You're right, but that doesn't justify him being there. And it seems to me that the prosecutor should get the right to put that before the jury, and those issues. And the question about, before this occurred, there was an incident where he said to someone, if I had an AK, I would shoot you. Now, and the judge did not let the prosecutor put that before the jury. And because he said that's commenting on his right to remain silent. Yes, you have the absolute right. But I don't think that's what the prosecutor was asking. It's how they frame the issues.
But if he said it without being given any Miranda warning, it's not admissible if the police elicited it.
But he was not being arrested for this incident. He said that before. They have it as a prior statement of this individual. So yeah, I think all the facts, when you look
Perhaps
at
an
it,
appealable issue.
then I'm not sure on that, because that goes to the facts that the jury heard. I think the only appealable issue is the dismissal of the weapons charge.
So, interesting. It's interesting that obviously there can be differing opinions when you hear the same set of facts. Speaking of which, so Vice President Kamala Harris and President Joseph Biden weighed in on this point. At least it was captured in a few mediums, actually. I'm going to go to a statement that I heard was attributed to Vice President Kamala Harris. And she was quoted as saying, my impressions about the verdict really speaks for itself. As many of you know, I've spent a majority of my career working to make the criminal justice system more equitable. And clearly, there's a lot more work to do. So it seems as if Kamala Harris was not, Vice President Kamala Harris was not necessarily pleased with the outcome. What say you, Judge Toliver?
I don't know what that says. It says something, but not really nothing. The verdict speaks for itself. Okay, we already knew that. And I've spent the majority of my career working to make the criminal justice system more equitable, depend upon which primary debate you listen to as to whether that was true or not. And clearly there's a lot more work to do. Mr. Tice, I have no idea what she was trying to say.
Your thoughts? Judge Smalls?
I think I go where the president said.
Well, we haven't gotten there yet. I'd like you to react to what Vice President Kamala Harris says.
I think unless you can find a legal basis for the jury being improper, I think the jury verdict stands for itself. That's our system of justice.
Yeah, well, without having the context for, and I'd probably have to do a little more research to get the context for her impressions. But I think it's fair to presume, underlining presume, that probably she had some of the same issues with the AR-15 that you seem to have.
You're probably right, but I agree with Judge Toliver when he says more equitable. What does that mean? I mean, you are entitled to a fair trial, not a perfect trial. You're entitled to put your evidence before the jury as you saw fit and as the trial does determine. Now, that's what happened. You know, you may not like the results, but that's what happened.
Well, sounds like you are to some degree supportive of the statement that President Joseph Biden made, and he is attributed with the following statement: "I stand by what the jury has concluded. The jury system works, and we have to abide by it." Your response to what President Biden said about the verdict?
I agree with him that we have to stand by what the jury said. Whether the jury system always works, that's a question that's always open for analysis. The jury have biases, they have issues and interests like everyone else. But I think once the jury has decided the case, the only recourse is if you find appealable issues. So the issue as to guilt or innocence is closed.
Understood. Sir, your reaction to President Biden's comment?
I agree with it.
The system works.
The system works. I won't say, and this may frighten both Judge Smalls and I, that we've agreed on 2 points so far. But it's not a perfect system. It is, matter of fact, maybe not a very good system, but it happens to be the best in the world. Does the system always get it right? In my 24 years, and Judge Smalls is 29 or 30 years.
Like 29?
And I've seen instances where I questioned the result, but mechanically it worked. Are there biases? The jury reflects the people and the community from which it is drawn, but I appreciated President Biden's comments, and I agree with them.
At this juncture, I think it's probably, since we're sitting in this particular jurisdiction, that is the great state of Delaware, just to talk about use of force in the state of Delaware. You can, if you are interested, anyone viewing this, interested in reading the law for yourself, it can be found by just Googling 11, assuming Googling is a word. You can Google 11 Delaware Code, section 464. And what you will find there is that Delaware has what in part I've heard lawyers refer to as protect your castle privilege, and that means in the home or workplace you have no duty to retreat. Is that both of you gentlemen's understanding as well of the law?
It's mine.
That's my understanding of the law, yeah.
Okay. Now, with respect to being outside of the home, it's a bit more restrictive, and this is where one has to be careful, because there is in the law a duty to retreat if you're outside of the home, and that means avoid confrontation if you can do so safely. Again, is that the understanding that you two have had in your careers?
That is my understanding of the law, and that's the way I've applied it when I was confronted with a decision that involved that statute or the principle. Yeah,
I agree.
yeah. But and I don't want to go off track, but in Delaware, self-defense is an affirmative defense. The defendant has to put forth evidence to support it. In Wisconsin, the prosecution has to disprove a negative, and I think that's
That's right.
difficult.
That's right.
Yeah.
So in terms of defending yourself, it makes it a little more advantageous if you're in Wisconsin.
If you're going to rely on self-defense, self-defense works better in Wisconsin because once you raise it, then the prosecution then has to disprove it.
Okay. And is that, and we've heard stand your ground, and I know pretty much every state, though they may mirror to some degree, will certainly obviously there will be distinctions. But stand your ground simply means, I guess, you do not have to retreat. Is that your understanding, Judge Toliver?
That is my understanding of it. You don't have to retreat even if it was safe to do so. Do you agree, Judge Smalls?
I agree with that. Yeah.
So next, I want to turn to the Ahmaud Arbery case, and I'm going to take a similar tact as I did when discussing Rittenhouse with both of you gentlemen. Setting the stage, and this actually happened before the incident with Kyle Rittenhouse. This happened back in February of 2020. Shortly after 1 p.m., Ahmaud Arbery was a 25-year-old former football player. Not entirely clear, but he had some kind of infirmity, and it's been called a mental illness, but it's some kind of auditory. They called it hallucinations of some sort, but from all I've heard, it was a normal, very active 25-year-old, very athletic 25-year-old, former high school football standout. And in fact, he liked to jog, which is what he was doing on February 23rd, 2020, which proved to be the last day of his life, unfortunately. He lived in a small city of Brunswick in South Georgia, and as I stated, he was taking a run in or around his neighborhood. I think the evidence is that at some point there was a house that was under construction or being rehabilitated, and he walked through, and I think there was some evidence to substantiate that. But as he was running, a man who was in his front yard, Gregory McMichael, said that he thought Mr. Arbery looked like a man suspected in several break-ins in the area, and called Travis McMichael his son. The men grabbed a .357 Magnum handgun and a shotgun, got into a pickup truck, and chased Mr. Marbury. Initially, they were unsuccessful, so apparently he was very athletic. Then a third gentleman got involved in the pursuit, and that was a Mr. Bryan. There was actually a 911 call from a neighbor just moments before the chase began, stating that a black man was inside of a house that was under construction on the McMichaels block. And according to Gregory McMichael's account, they yelled, "Stop, we want to talk to you." They pulled up to Mr. Arbery, and Travis McMichael got out with the shotgun, and apparently at that point, that's when a struggle ensued for the shotgun. Well, I guess there was a physical affray first, then Mr. Arbery was shot 3 times, twice in the chest. Interestingly enough, it took, I believe, about 73 days for, as we speak about process, for those gentlemen to be arrested and charged. Mr. McMichael was a former Glenn County police officer and a former investigator with the local district attorney's office. I think that's what's been pointed to as an explanation for the delay. And there's been other statements attributed to some folks in the district attorney's office, basically finding no probable cause to arrest him. And obviously that decision was later changed. In the closing statement, the lead prosecutor said the defendant had launched an attack on Mr. Arbery because he was a black man running down the street. The defense countered for the McMichaels, at least, that the gentlemen were carrying out a legal citizen's arrest in an area that had been gripped by crime concerns in the months leading up to February 2020, when Mr. Arbery was running or was chased through their neighborhood. And they argued that Mr. Arbery, again, none of us have seen all the facts in the case or heard all the facts in the case, but they asserted that this was a recurring thing that Mr. Arbery did, and that his actions were frightening and unsettling. Ultimately, the gentlemen were found guilty of, take a look here, malice murder, 4 counts of felony murder, 2 counts of aggravated assault, 1 count of false imprisonment, 1 count of criminal attempt to commit a felony. Now here, different from the Rittenhouse case, at issue was citizen's arrest. And again, the gentlemen were found guilty in that case. The third gentleman, Mr. Bryan, tried to distance himself, indicating that he was not aware that the firearms were possessed by the 2 gentlemen, but he was found guilty nonetheless. Citizen's arrest, obviously it did not serve the defendants well in this case. What's your reaction to that, Judge Smalls? Citizen's arrest in Georgia.
Certain jurisdictions do have statutes that permit a private citizen to arrest. But in this case, what is the crime they're arresting him for? They allege that he committed burglary, but burglary is entry with the intent to commit a crime or committing the crime while you're there. There is no indication that he had committed, was committing, or was about to commit a crime at that time, except the most you can say he was trespassing. And I think that doesn't get you to a citizen arrest with deadly weapons. And I think that's the difference in the two, is that we have an innocent person running in a city where he lives. He stops by on a house under construction. He doesn't move anything, doesn't take anything, and he had encountered for a citizen's arrest. The only factor which you could use to justify is race. That's the only factor here. I agree with the prosecution. Race was a factor. That's why they targeted him.
Speaking of race, before I get to you, Judge Toliver, the Georgia citizen's arrest statute has come under a lot of fire, and probably in large part because of Georgia's pretty much ignoble history with respect to slavery and certainly the Civil War era and such. And this particular law was passed in 1863 during the Civil War era. Slavery was still considered legal by Southerners at that point, despite the Emancipation Proclamation. And the law stated that a private person could arrest an offender if the offense is committed in his presence or within his immediate knowledge. And I believe certainly those in academia, legal and otherwise, certainly have concluded that the citizen's arrest statute in Georgia was a slave catching law for slaves that attempted to flee. So what were your thoughts? What was your reaction to that defense being employed?
First of all, I'm not sure, was it for certain that they saw him in the property?
They did.
I don't know that they saw him. They certainly saw him running.
Yeah.
And I think there may have been some inferences drawn by them.
Well, there's a couple things I'd like to point out. The first is that the evidence was a number of people. He might have been only black, but there were several whites who had come to look at the house who was being constructed. The McMichaels didn't own the property. and you can't use deadly force to protect property alone, and it wasn't occupied. So I'm not so sure. Well, it was the only defense they had because it was clear that this guy wasn't bothering anyone. He looked, he didn't have anything in his hands. He was in jogging shorts, I think, and he was just running down the street in broad daylight. Now, I'm not sure you need a shotgun and a .357 handgun to effect a citizen's arrest. Maybe you do, maybe you don't. But I do not see where he in any way contributed to it. He's in this neighborhood, and these guys come up in a pickup truck and get out with weapons. The only thing I could think he did wrong, he should have run a little faster and a little further. Not that you could outrun bullet, but I do not. The only possible issue I have with the verdict is the guy who took the videotape. He may have a case on appeal, unless, and I don't know all the facts, but the other two, we used to say is guilty, I think my parents used to say guilty of sin. I don't know, their explanation didn't make any sense, except they didn't like the idea of a black man running through their neighborhood and doing what other whites had done, i.e. look at the property, walk back out again. I didn't understand that, but you spoke about the delay. My understanding, I don't know if it was true or not, but because this guy was a former police officer, there were a number, and he knew the people, there were a number of conflicts. And each time it was passed, and I have seen cases where with judges there would be conflicts and it would have to be assigned to another judge. Now that's not the charging authority, but I don't know, but whether it took 73 days was justifiable or not, they did indict, and I think the right result was reached.
And I think we should also point out that this law, which was certainly outdated, and in this particular case, lethal, meaning the Georgia Citizens Arrest Law, has been repealed, and it was replaced, according to my sources, what I've read, with a bill that limits who can detain citizens and when, i.e. business owners and workers who actually witness someone shoplifting or dining and dashing, et cetera. But most states still have a version, and in fact, Delaware has a version on the books. And if you are interested, again, speaking to those who may view this, in reading Delaware Citizens Arrest Law, it's actually 11 Delaware Code 20, Section 2514. And we don't see it often, certainly, in terms of citizen arrest in Delaware, and we would frankly discourage it. I think I can speak for all of us. That's why we have a very able police forces locally and statewide in this particular state. And I won't go into too much detail with respect to the Delaware law in that regard. But so you two agree again? The jury got it right in Arbery?
I think the jury got it right as to the charges. There's clearly no basis to encounter this individual except to call the police if you see someone on a property you do not own and do not occupy and have no vested interest.
Yeah, and I think when we go back to the concepts that we spoke of initially of justice and fairness, I don't know, was this a decision that brought, those with racial grievances on both sides? Did this bring us closer together?
It's hard to say. I think those who were on one side beforehand, who would have called or chased Mr. Arbery or called the police, still have their feelings, and I think those who were on the side of his family still have their feelings. But I think it's the process that's most important to me. And someone once said, because I used to do mediations, where someone would say, you know, the best decision is the one that leaves everybody unhappy. And I'm not saying that applies in the criminal justice system, but it was a fair trial, and I would have to go back to the Rittenhouse case. I may not like the verdict, but procedurally, I have a problem attacking it. And going back to something that Judge Small said, I feel fairly certain here in the city of Wilmington, state of Delaware, that you wouldn't be allowed to go to a protest with an AR-15 hanging around your neck. Whether you had a constitutional right to do it or not, I think they'd find some way to keep the people separated.
As a practical matter.
Yeah, I agree with you that the police in this state is pretty sincere in trying to find where trouble may occur and trying to anticipate and, of course, resolving that before it reaches this type of level. And I can't think of any police agency as that anyone comes to any type of protest with that weapon without having some officer walk up to them and say, I think there's an issue here. You need to leave, or we're going to take the weapon. I think that's fairly confident about that.
As we go to wrap this discussion up, I just want to have I want to ask a general question. It's the holidays, and this is always typically known as a time of reconciliation. And I just want to ask you two gentlemen the question. I mean, is this? I mean, just kind of the tenor, the tone of some of the discourse in this country, and I've called it here racial grievances on both sides tonight. Socially and politically. I mean, is the divide too great to reconcile?
I hope not. I think it's a rather large divide, but I think there are well-intended people on both sides who want to seek some common ground. Now, there's always going to be that fringe element on the right and on the left that I think you're never going to satisfy.
Sure.
I think I come back to what Judge Toliver said before, is that we don't have a perfect system, but we have the best system. And I think all of us need to be a little bit more tolerant, more understanding of the other person's point of view, and you don't have to look like me, dress like me, or act like me to be a good person. So you cannot assume the worst, and you should not act as if the person is doing something bad. I think we need to do that. And I think a lot of our leaders and places understand that now, and they're working to do that. Because we have no alternative. We have to make this better, because we all have to live in this society together.
And I think that takes understanding on both sides. We talked earlier about inherent, implicit biases. And the question is not whether you can get rid of them or not, but whether you understand what they are and you try to remove them from critical thinking, viewing people differently because they don't look like you or talk like you, and recognize, well, I may look at Mr. Tice differently because he's taller. That's an okay bias in my mind. But seriously, we've got to recognize how we feel and learn to speak openly about that.
I think I agree with you two gentlemen. As long as, on both sides, we have life, I view life itself as a possibility, and there's the possibility of a shared dignity, and if we can do that and put aside, as you stated, Judge Toliver and Judge Smalls, the certain things that we identify with, the certain prejudices and biases that most of the time are not even original thoughts. It's stuff that we've learned from outside, most often those who we respect. You know, if we can discard those things and just identify as humans, rather than those things, again, that we identify with and the prejudices, I think that reconciliation always remains a possibility. With that, I am going to close. I thank Judge Toliver, former Judge Toliver, former Judge Smalls. If anyone, of course I thank each and every one of you who will watch this. We hope that you found this informative, somewhat entertaining, but if you have any questions or would just like to reach any of us, we can be found by calling 302-489-2400. That is our office. We would welcome your phone calls. We consider ourselves a resource. Feel free to call anytime with any issue you may have. Bless everyone and have a happy holiday.